Afternoon, everyone. Just letting you know that we will be starting this session in about 3 minutes. We've just got a few more people logging in. So just give us a few more minutes and we'll kick things off. Thank you.
Can you hear me, Arun?
Yep, all good, Franco.
Good.
Good afternoon, everyone. I hope you're safe and well, particularly if you're joining us from across the Middle East. Thank you for taking the time to join what I'm sure will be an extremely interesting live podcast. My name is Jason Sandaukar, and I'm the editorial director for the Built Environment and Heavy Industry divisions at CPI Trade Media. For first-time participants, CPI Trade Media is actually a media company behind the Middle East Consultant brand, which comprises a B2B magazine as well as live and virtual events. I'd like to start off by saying a big thank you to our long-term partners, HKA, for partnering with Middle East Consultant to host this session. We'll be focusing on the impact and disruptions conflict can have on construction projects, which I think is a timely and hugely topical session, given that we're now almost 3 weeks into this regional conflict. I'm sure that our 3 regional experts from HKA will have fascinating insights to share on the potential issues stakeholders can expect, how companies can actually protect themselves, as well as some potential workarounds. The session will be moderated by Haroon Niazi, Partner Construction Claims and Expert Services Lead EMEA at HKA. Haroon will also be taking questions from the audience at the end of the session, so please do share them with us as it goes along. We will also be discussing this important topic as well as shining a light on enhancing construction efficiency, collaborative construction, and avoiding disputes, improving quality, as well as achieving sustainable outcomes through new processes and technology at the 2026 Value Engineering Summit. That event will actually be a live event and is due to take place on 15th April in Dubai at the H Hotel. If you're interested in attending that event, please type into your browser 2026.valueengineeringsummit.com. Now, before I hand over to Haroon to kick off this session, I'd actually say a big thank you to the UAE's leadership, the armed forces, as well as all the government entities for doing an absolutely brilliant job of keeping us safe and enabling us to go about our daily lives during this conflict. They've been and continue to be absolutely phenomenal. So thank you again for joining us this afternoon. I'm sure you'll find it time well spent. Over to you, Haroon.
Thanks a lot, Jason. Thank you for the introduction. Good afternoon. Assalamu alaikum, everyone. If an alert comes through and you see me jump, that happened to me earlier in the morning when an alert buzzed through and I jumped out of my chair. So let's hope we don't get any alerts at this time. We are seeing disruption to shipping routes following the closure of the Strait of Hormuz, and there's delays to the movement of critical equipment, materials. There's increased logistics and insurance costs that are not far on the horizon. And in some cases, we are seeing missile and drone activity affecting key infrastructure. Now, on the ground, some projects are dealing with safety alerts. There have been temporary site closures and even the demobilization of personnel, leading to stop-start work and productivity challenges. Now, many of us on this call today, we are living this. And the purpose of today is really to share some insights, because at the end of the day, we are all in this together. So the key question that we want to explore is, what does this mean for projects right now? And how should the industry respond? I'm very pleased to be joined by two of HKA's leading experts, Dr. Franco Mastrandrea and Derek Nelson. Now, Franco is a partner with HKA. He has over 40 years of experience in the construction industry. He's a Lexology Index Global Elite, a thought leader, and an expert in international project management, delay, and quantum-related disputes. Derek is a partner at HKA. He's a fellow of the Academy of Experts with over 40 years of construction industry experience. Now, Derek is a leading author and an expert in disruption, delay, and quantum matters. Thank you, Franco and Derek, for joining us today. I think I'll start with Franco in the first instance. Now, we're quite fortunate in the region to have a healthy pipeline of projects. But before we discuss projects under execution, let's take one step back and think about contracts that are just about to be signed, particularly where contract amounts and perhaps time has already been negotiated. And I think there's some resemblances with COVID days for many of us on this call. But how should a contractor, in your view, be moving forward in this situation?
Thank you, Haroon. Well, I would have thought that in circumstances where the contract is not yet executed, it may make sense for the contractor to discuss possible arrangements with the client to perhaps agree that during the period of these difficulties, or perhaps deferring the works starting in earnest, that during that sort of period, perhaps an agreed rate for the contractor's involvement with some limited mobilization at costs to be agreed, rather than start in on the contract and have immediately to take in the particular provisions that may deal with these sorts of events. So I would have thought that perhaps that might be something which could be agreed ahead of time and perhaps lead to a methodology of dealing with the costs incurred for the contractor to be involved, the degree to which may also be the subject of agreement. So perhaps key management resources dedicated nevertheless to the project because the client wants the project at some hopefully short point in the future to go ahead.
I think that's key because some of the challenges faced in the region, and Derek, feel free to jump in here, is around proving costs. So if a contractor signs up as of today, knowing what's happening in the region, it will bring different challenges when you think about the risk and challenges with proving costs that might be incurred as a result of the conflict.
I maybe just add, if I was looking to enter into a contract, if I wasn't already locked into a set of provisions, one of the key things I would be looking for is to ensure that that contract has a fluctuations provision. You know, if you go back to events that occurred kind of during COVID, I remember sitting at one point and the cost of timber was going up 10% per week. Anything that was related to plastic, anything that touched oil was, you know, the price increases were significant. So as we sit today, you know, we're only 3 weeks into something that we don't have an end date for. Don't know how much effect it's going to have on procurement chains, but at the moment, air fuel is up 50%. You know, kerosene is up 50%. Shipping is being disrupted. So that whole effect on your procurement chain, not just in the Middle East, but that is then likely to ripple out across other regions. So where you start having the effect that is disturbing the ability to move materials, equipment to sites around the region and beyond, If you have a provision that allows you to track and compensate for fluctuations in costs, that takes an awful lot of the headache out of the commercial concerns of signing up to the projects that are coming up. And that gives a degree of certainty for both the owner and for the contractor. Because usually there is a margin in there that the contractor would have to bear. So there's a risk element that he would be accepting for that certainty. But then you're not down to having to prove increases in actual costs. You move on from that position.
Because I've got my two hugely experienced colleagues on, I'm gonna go off piece sometimes and ask some questions that we didn't think might come up. But Derek, one thing I wanted to just pick up on the point you just made, and then I'll come back to Franco when we touch on contracts. But with the fluctuation costs in particular, and proving fluctuation costs, from your experience, what should a contractor be considering at this point now from just that cost proving perspective on fluctuation?
If you don't have a mechanism within your contract, then you are at the disadvantage of having to prove what was reasonable when you entered into the contract, what that expectation would be. And it wouldn't just be the costs that were incurred or in kind of market costs at that time. There would be an element where you would expect on a 4-year project, you would expect materials to fluctuate. So it's not just a case of setting the benchmark of where did you price that? What were your expectations? Were they reasonable? So just getting to the starting point is a lot of effort and a lot of pain for most contractors. And the demonstrating that that was a reasonable expectation is always an uncertainty. And then you have to be able to track actually what did it cost and what could you have done to mitigate that cost. Because if you had the foresight to buy those materials in early at a lower price and hold them, then you wouldn't have incurred those additional costs. So there would be lots of arguments about what was reasonable behaviour. What actually have you incurred loss? What could you have mitigated? Why didn't you do that? So you're opening up a raft of questions that then require evidence and proof just to get to a point where you can ideally get to a sense of what that loss actually is. And that's expensive. That takes time, that takes effort. It takes an awful lot of records and information. And regrettably, most contractors don't really do that. So if you can have a mechanism built into the contract to begin with where you have reference to a particular set of indices that are agreed up front and you contract using that, you take an awful lot of that effort and pain away. But it's having those provisions in your contract to begin with, and quite often that's not the case. So if I was sitting today looking forward, I would want the comfort of that. And if I was the owner, I'd also want the certainty of that.
I think that's an important point. I mean, it's certainty for the owner as well. It's not all about passing the risk to the contractor. You mentioned contract. I'm going to go bring Franco in. We've heard a lot's been mentioned, a lot of discussion already around force majeure. Franco, what contractual mechanisms typically come into play now? What should contractors and employers be thinking about?
Well, obviously, the important thing, first of all, is to look at the contract and see what express provisions in particular there are in the contract. And typically, one might see force majeure and exceptional event type provisions in the contract. And clearly then, one has to see what sort of relief there may be and what requirements there may be by way of notice provisions in those circumstances. So I think it's important, first of all, to see what the contract says expressly, have a look at the list of events which may qualify as either exceptional events or force majeure events, and then see what the provisions allow you to do. They almost inevitably will require a notice of some sort, probably time limited, and probably in most cases regarded, certainly in common law jurisdictions, as conditions precedent to any relief. And so one would have to be very alert to the express provisions and operate them accordingly. Some of the relief may be limited in the sense that if delay is incurred, there may be a relief by way of extension of time for a contractor. Others may also have recovery of cost or loss associated with them. So again, it's important to look at those provisions and see how they impact on the ability for relief and for positive returns by way of reimbursement of costs and losses.
I think it's also just important to add as we've seen in the region, contracts have become quite complicated. Force majeure clauses were amended quite heavily post-COVID, so certainly bringing in legal counsel quite early to ensure that notice is correctly drafted is key. And you make references to the different provisions. I mean, we're seeing already certain sites that are secured by way of National Guard, for example, critical sites for the region. The National Guard is preventing access to the site for safety reasons. So there's different access constraints that I think contractors will have to consider when considering the cost claims.
Indeed, yeah.
What kind of financial losses would you consider, Franco, that will be felt now, but what is there for, given your experience, what do you see on the horizon here? What should contractors in particular be considering from now, looking ahead? And also the employers. I mean, there's risk both ways. What about from the employer's perspective, would you say?
Well, I think employers must expect that if there is going to be financial relief for the contractor, they must expect that costs incurred by contractors by way of additional transport costs or additional insurances or even a reduction in insurance cover and how that might affect the contractor's own costing system. And they must also be prepared to make adjustments to the way in which the work is carried out, perhaps rearranging the program and agreeing a way forward, which will also, of course, impact on the employer's own costs internally and by way of the provision of engineering assistance, architectural and other third parties will also be affected, and the employer must have regard to that and its own internal costs.
I think just adding to that, employers should, I would suggest, if they haven't already done so, you need to go and have a look at the provisions they have for project insurance. Because if we are talking about things that are essentially business interruption, whether that is because of kind of stop-start scenario or additional costs that are coming out of extraneous interventions, employers' first protocol would be to see, is that covered by my insurance? What do I need to do? So again, there are notice requirements that they would have to be given in order to be able to call upon that, assuming that their cover actually has the appropriate provisions. And I would be quite surprised if most of them did not, given the the kind of capital expenditure in that region. I would think that it would be a fairly bold owner that didn't actually have levels of cover that he could call upon. So again, having an eye on where are your abilities as an owner to offset or to recover costs through other mechanisms, and rather than, I guess, a very kind of old-fashioned, I will just reject everything and we'll end up in a big dispute. How do you actively manage that and resolve that?
Franco?
I think the employers in those circumstances, of course, also have to think about the transactional costs involved in even getting insurers to pay. I mean, there'll be a process there that they will have to go through, and that will take time and money. And so those are all things I think that one might expect to have to deal with.
Sure. Franco, you sit as arbitrator quite frequently. And the point Derek just mentioned about employers simply rejecting such claims, we do see it quite often in the region. With your arbitrator's hat on, how does that look years down the line if that's been the behavior of the employer, would you say? How would you consider it?
Well, I think outright rejection without reasons would not be viewed unfavorably by tribunals. So I think it's a dangerous approach to contractors' valid claims. I would have thought much more helpful would be to have regard to them, appraise them, and then, if appropriate, reject them, because that is something that will, of course, be important for the tribunal to understand.
Sure. I want to just move on to disruption, and perhaps I'm conscious of time, and perhaps we spend the next 10 minutes or so talking about disruption. And folks on the call, if you do have questions that are coming to mind now, please drop them in the Q&A box, and we will pick them up later on in this session. Now, I'll go to Derek. Derek, many of us on this call have struggled with disruption claims in the past. You have a fondness of disruption claims. Can you talk to us about the different ways of proving disruption? From your experience, what kind of records will be needed to prepare disruption claims? And given where we're at now, and relatively we're in day 18 of the conflict, what could a contractor be doing from now from a record keeping perspective? They may not have the best records to date. They may have, we don't know. But from the here and now, what do you think from a record perspective and the kind of disruption that might be faced?
Okay. I think just to give a degree of context, so we did a review of 316 judgments that came out either of courts or tribunals relating to claims that were presented for disruption. And only 37% of those claims were successful. And the biggest failure that came out of that review in my mind wasn't the quantification of disruption. It was all the prerequisites to demonstrate entitlement to claim disruption in the first place. So, being able to set out the basis of entitlement, to be able to demonstrate that there was a compensable breach of an obligation. So, again, going back to the contract and the balance of risk within the contract, and then to be able to actually demonstrate causation and support that through the records on site before you get to quantifying loss. So those are the kind of three steps that you would expect to go through. What we often see is an assertion that this has happened, it must have caused disruption, and therefore I should be paid X. That's completely inadequate. So as in any claim, you are making an assertion as to an entitlement. It's inherent upon you to be able to demonstrate that. So you have to go back to kind of basics and establish what is the basis of my entitlement. How do I actually demonstrate causation? And that's where the records actually come to play. And then the last part is the quantification. And there are a raft of ways in which you can actually quantify loss in a disruption context. But I think the key aspect that often is missing or is insufficient is the demonstration of causation. So being able to actually record what's happening on site as a consequence of the complaint that you have is incredibly important. And that's where contractors tend to be terribly weak. And I can understand that to some extent. If we are talking about disruption that is arising as a consequence of change in a project, quite often that's not patently obvious at the time. That is having an impact on works round about that particular change. But in the situation that we are at the moment, where you have interruption to the project, whether that is a case of you're having to remove people, have them shelter and then go back to whatever work phase they were engaged in. The obvious way to do that, to my mind, is to strip out the lost time that is caused by moving people, sheltering them, bringing them back to that work phase. I would ring fence all of that, have that recorded, and you should be able to do that easily. Identify who the individuals are, how much they cost, what the time was. You have to give notice of all of that in any event. Quantifying that should be relatively straightforward. And then the disruption component, and that's the loss of productivity, all of that stuff before that, essentially I would say that is idle time, and it's something that you can discreetly quantify and present. And the disruption element is the loss of productivity, getting back to the output levels that you were at before you had to stop. That then becomes relatively small. What I have seen on a lot of projects is people put forward a generic disruption claim and they put a sum of money against it, but they don't break it down. They don't make it visible. Whereas if you can segment it into those particular steps, so you get an alert, you have to demobilize people, you have to take them to a location, whatever that distance is, how long that takes, and you quantify all of that discreetly in those packets of time and cost. And then you look at, okay, so after all of that, what effect do I have to compensate for getting back to the levels of production I would have been at but for that interruption? So take the interruption, ring fence it, and then look at the balance. So you're not throwing everything in one basket. And if you have failed to present sufficient evidence for a component of that, the whole lot is in danger. So making it visible and breaking it open is the first thing I would look to do.
So you mentioned basket, and sort of, Frank, I'll come back to Derek's point about his baskets, and just.
Can I just add a couple of points? I think one of the reasons why disruption claims do have a low success rate has often been because what you're dealing with usually in that conglomerate that Derek describes, and I agree with him that it makes perfect sense to try and break it down into more manageable and understandable parts, is that you're typically dealing with incremental costs. Unlike a delay claim, for example, where contractor's making a prolongation costs claim and is claiming the whole of that sum for the resources that are on site detained for that period. Whereas typically with a disruption claim, you're looking at the difference between outputs. And that is one which is really challenging in terms of persuading tribunals about the measure of, and you inevitably get to quite diametrically opposed views, particularly from experts. One of the other things that can be done, I think, is not to be obsessed with delays in the way that typically we are, and that is simply to concentrate on critical project delays. There are lots of other activities which are likely to be delayed locally, not on the critical path, but where the costs which are added by way of a prolonged activity can also be measured. And therefore you get away from the need to put all of your eggs into that loss of efficiency basket.
Just on we lost you for a moment, Derek, but we're talking baskets. Just in terms of, so you've got the basket of people who are on site and they have to demobilize to shelter. Franco's just raised the situation where non-critical activities are being delayed and disrupted. How would you package that into a we're going to use this theme of baskets here. How would you package that into a basket? Should the contractors be notifying employers early on specific activities? You've got the whole challenge of wizardry of P6 programmers to deal with at the same time when you're looking at non-critical activities. What's your view on that? And I think, Derek, you might have something to add as well, I think.
Well, I think the important thing is on that, a really good record of what actually happened. You know, what does the as-built picture look like, but not restricted to those items which fall on the critical path. You're looking at the whole job. So you need to understand when things were done on particular activities right the way through the job. And there may well be reasons why local delays are caused which don't hit the critical path, but they have their own story associated. And therefore, those records and that understanding and that history becomes important too.
Sure. Derek, do you want to, you're just on mute, Derek, I think when you've logged back on.
Sorry, I forgot to turn my microphone back on. I think absolutely. There's an awful lot of money that actually gets left on the table or ignored because there is disruption to parallel activities that don't drive completion of the project. So, if you have restrictions on site that are imposed, it means that you have scaffolding standing, for instance, or plant that cannot be used. It's not associated with a critical activity. If that is because of some hindrance or breach, that is still recoverable. So there's a big difference between what is the disruption, what is delay. And regrettably, we still have that kind of twin term where people refer to delay and disruption as somehow they are the same thing. They are not. Very different.
Sure.
So you can have an entitlement to recover costs associated with a loss of productivity that has no impact whatsoever on delay to completion of the works. You could have an entire section of the works that don't sit on the critical path, that your productivity crashes because there are a number of consequences around change or hindrances on access or being able to progress particular aspects of the work, or lack of design approval, etc., that don't touch on completion of the overall project, but still cost the contractor a loss. They should be able to recover that if they go through that process, establishing the entitlement, the breach, causation, and quantifying the loss.
And I think
the thing I would just add to that, if I can, is a lot of that occurs, in my view, because there isn't a mechanism to identify it early. So we get to the end of a project and suddenly contractors discover they've spent more than they had intended, and it's almost like a last prayer, we'll put a disruption claim in. And it's poorly presented, poorly justified, poorly quantified, because had they actually recognised at the time that they had this issue with productivity, they could have done the appropriate records. They could have brought all of that material together at the time. So having a mechanism that allows you to identify there is a problem and then to be able to investigate it is very important. And I would suggest that today, because we are now we now have main contractors that, quite honestly, often don't actually directly employ the people that are doing the work. It's all subcontracted, and then it goes out to a labour-only subcontractor. And if you're the commercial manager on that project, you might hear about it a month later, 6 weeks later, 2 months later. That's far too late. You need a mechanism that allows you to track, I would suggest, earned value at a project level within those sub-works, so that you can see where things are going wrong. And even at that, you have to recognise that productivity is not a constant. It will fluctuate.
I'm going to bring Franco in now, Derek, because we've started talking disruption, and we're going to lose a whole hour on disruption. So Derek, Franco wanted to add something to that. Quite an important comment there you made. So I'm just going to bring Franco in to the
only thing I would say is that in relation to those localized delays that I identified, they will have their own discrete time costs. The supervisors the managers of that work, which may not feature, of course, in the time-sensitive project costs. So that sort of sublayer of time-related costs, in my view, are well worth looking at.
And I think, I mean, there's a lot of technology now available to us, and the project sites have technology, how people are being tracked, whether it's tagging in and out of a site or the locations where they're working on a site. So the technology will also help on a claim. I do have a question about system dynamics that I'll come to you shortly on Derek. But you've mentioned baskets, and there are some critical infrastructure energy type projects at the moment where there is no work. Contractors have had to demobilize due to restricted site access for health and safety reasons. And where does that basket of costs sit? How would you frame that? What's the best way, would you say, in your experience, to frame those costs as compared to some of the other costs that you've been, both you and Franco have mentioned?
I would split them up. So if you have an instruction that you have to demobilize from a particular site, you're going to have an element of work where it is essentially making safe, protecting wherever you are at that point in the project. You then have to demobilize. You're then going to have whatever costs you cannot offload. There are certain things that you are going to have to retain, I suspect, particularly where there is clear uncertainty as to how long you're going to be off site for. So there may be pieces of plant and equipment that you cannot off-hire easily or cannot off-hire and bring back again with any degree of certainty. What do you then do with all the supervisory staff? You try and retain them or redeploy them? How can you actually mitigate some of those costs? What do you do with the actual labour on site? And then you have the kind of back end of that. When you get the instruction to go back again, you've got all that remobilization costs. Now, at that point, you might discover you cannot get the people that you had previously. This was a big problem in the likes of COVID, where you had specialist squads that were doing, particular types of welding, for instance, and you couldn't get the same qualified people back to complete the works. You then had a whole host of issues that came off the back of that. So the remobilization costs you should be able to bring together fairly discreetly. But it then is a case of bringing the people that you have brought back to the project up to the production levels that you had previously. There was all that revised learning curve, essentially starting the project over again.
Would you put that as a separate basket of costs? Would you try and split that?
I would take all the kind of the protection to begin with, and I would ring fence that, because that's going to be quite inefficient. You then have the demobilization costs. I would ring fence all of that. The costs that you are having to incur in terms of the period of suspension, whatever that is, I would present that separately. And then when you're coming back to having to try to remobilize and restart the works, I would take those two things separately.
I'm just going to ask Franco to touch on, and as you've mentioned a couple of times now, mitigation, Derek, and there's delay as well as cost, and you've mentioned mitigation there. Franco, what is the contractor's obligation to mitigate? What does that look like?
Well, again, I think we need to be clear about what the contract terms may say about that, because there may be things that the contract requires in response to particular problems. So, for example, there may be a provision in there that the contractor should make best efforts to reduce the amount of delay. That probably, by contrast to a contract which didn't include those provisions, would probably result in a different answer on mitigation. I mean, mitigation typically, as we know it in the law, is a response, if you like, which comes from the defendant, who says, well, look, you've incurred costs unnecessarily, and therefore I'm not going to be paying you those costs. So a contractor can avoid costs and should avoid costs in response to a breach of contract. And so that typically is where the mitigation issue arises. But as I say, contractual provisions may actually require some particular response. Take an example where an employer, and you know, it's not an easy thing to even contemplate initially, but an employer, in response to a traditional claim, one of the areas of mitigation may well be for he or his expert to understand the subcontract terms between the contractor and the subcontractors. Why? Because that will have terms in it which may place the responsibility for something which is now featuring in the claim with, say, the subcontractor, in which case the employer would say, well, you should operate those provisions, operate the subcontract terms, and save me the need to pay those costs, because that's an arrangement you already have. And therefore, understanding those terms and having them in play becomes quite an important feature of looking at the way in which an employer can mitigate his or her costs. Another example would be, you know, items, Derek mentioned plant. I mean, plant standby costs typically are going to be a fraction, or at least should be a fraction, of the working rate. And therefore, in that sense, you're not talking about paying a full rate simply because the plant is standing. It's not being consumed, as it were, and has perhaps a life which is going to be being able to be used in due course when it's consumed. So I think all those things in terms of mitigation become relevant, but the important thing, I think, is to understand, are there express terms in the contract that require certain things to be done? And if they do, are they going to lead to a contractor's ability to recover costs associated with it? And you know, that very much depends on the express terms.
I think there's a whole piece around strategy here from a contractual perspective, a claim preparation perspective, and really having that foresight now of getting, one would say, getting everything at home in order, so that you don't have some of the challenges that Derek, you mentioned later in the day. I'm going to try and take a few of the questions that we have now. One question that came in, and I'll go to you in the first instance, Derek, is what's your view on using system dynamics to prepare a disruption claim in the current scenario that we've been describing? I know I've asked you because I know you've written about system dynamics, so that's why I'll come to you first.
A number of very large disruption claims that have been presented off the back of that, and mixed results, I have to say. I think in the context of where we are today, it's probably overly complex and overly expensive and unnecessary, would be my initial thoughts. So there's a case that, if you want to go and look for it, you'll find it on the internet. Large development in Egypt, whereby if you did a traditional disruption analysis, I would suggest it would probably have cost about $150,000 to undertake that and present that report to the tribunal. To do exactly the same thing in systems dynamics, it was $1.5 million, and it wasn't terribly successful, because one of the biggest issues with an SD model is the factors that are applied to quantify the outputs. So the theory is great. It's the model that then becomes the crux of whether or not you're going to be successful. And there are certain consultancies who essentially will not open up the mechanism as to how they have assessed and quantified the outputs. No tribunal is going to find that terribly persuasive. And it's a very easy thing to then challenge. Whereas traditionally, SD came about in 1970s, I think, in terms of construction, was spun out of MIT, bought by PA Consulting. They had a number of very large disputes where they simply refused to open up this black box and explain how the thing worked. That did not give a great degree of credibility. So if I do a comparison, 1970s was roughly when critical path analysis came into vogue in construction for delay. That's now accepted as normal. Every dispute that you have a delay on, there's a CBM analysis somewhere, usually. Systems dynamic came about at the same time. It hasn't gained the same traction or acceptance because there are issues with how you actually quantify off the back of it and how you can then justify the interrelationship between 6 different factors. It does come down to the validity of the model, how you present the evidence to the tribunal. But for what we're talking about today, I would suggest it is overly complex, overly expensive, unnecessary to be able to advance entitlement if you are in a position where you can break things apart and quantify them discretely and demonstrate that cost discretely.
I think you've summarized that.
And potentially dangerous because the tribunal may actually dismiss it. I'm reminded many years ago when critical path analysis first made its appearance. Tribunal asked the expert, "Are you telling me that what you've done is you've fed all these things into a machine called software and it churns out the answer at the end?" And the answer was yes, and it got pretty short shrift in the award.
I'm going to ask you another question off the back of that answer, although not entirely linked, Franco. It's reference to FIDIC, and if the adjustment for cost, the subclause for the adjustment of cost has been struck out, the question is, is the contractor entitled for cost escalation and prolongation cost if an extension of time is granted?
Well, are we talking? Well, look, let me presuppose if the
we're trying. I've got a few more questions, so I'm going to ask you to keep it because I know this.
Oh, okay. Well, look, it really depends on the cause. You know, if the cause is some sort of employer default or breach, then yes, I can't see that there would be any reason not to do that. But if it's what we might call a neutral cause, and you know, depending on the contract terms, the interference we're talking about may be a neutral cause, then I think you probably would be in the realm of getting an extension of time at no cost.
Thank you. And Derek, in terms of notices, is the notice requirement condition precedent, and should it be strictly followed to preserve entitlement, would you say?
I think that comes down to the jurisdiction that you're operating in. You know, kind of English law perception would be it would bind, and therefore it would be effective. You can go to other civil law jurisdictions whereby if it's regarded as not being equitable, it won't be enforced on that premise. So again, it comes back to what does your contract provision state, but what legal jurisdiction are you operating in? And at that point, I suggest we don't obviously provide legal advice, but you need to understand what your rights and obligations are to be able to put that forward. And it may be that you have to then present a series of alternative arguments.
Thanks. I think investing now in early legal advice, we've got new civil code in different parts of the region, so the law plays a key impact. So I think getting in external counsel now is key. Franco, another question here is to do, and it might be one for Derek as well. What aspect of a stop work instruction stroke suspension would be treated as a variation, would you say? And specifically where the contract says that any impact due to the instruction or force majeure exception is subject to the variation clause itself.
the stop work is subject to the variation clause.
Yeah, yeah.
Okay. Well, I'm not into. I think it would very much depend, I'm afraid, on the terms. If the definition of a stop work order is that it takes you into a variation, then I guess the mechanism would have to be followed as to how you go about valuing it and getting the engineer to determine what the value is. I would find it quite challenging to describe in the normal course a stop work order as a variation, simply because variations are more usually to do with the specification quantity of work, although of course there are contractual provisions that also treat variations as matters that go to the order in which work is done or the programming of work. So I think, again, I would look at the provisions. If by definition it takes you into the variations, then you need then to operate the variations provisions and their valuation, including at the end, I suspect, an engineer's determination, and if not, a dispute.
Sure. I want to just talk a little bit about delay. We haven't got long left in today's session. Now, where projects are already under execution, so contractors have been on site, but there has been delay, or differentiate from your perspective, Franco, on delay already accrued and perhaps delay that will now happen due to the conflict. And there's a real scenario here, like we saw in COVID, where potentially there's a masking of one over the other in terms of the events. What's your view on that?
Yeah, it's sort of classic colour of the front door argument, where the last event is the one that all the delay is attributed to. And that really won't wash with most tribunals, I'm afraid. So if there is a delay that's quite clearly going to lead to a delay to completion in due course, subject to one argument, which I'll come back to in a minute, it's very unlikely that the tribunal will not have regard to that accrued delay and treat it as caused by the party that has led to that delay. There might be an argument from the contractor that says, well, in those circumstances, I could have avoided that problem by taking some measures to overcome it. That would, of course, would expose it to the argument, well, okay, you would have incurred costs to do that, and so they'd have to take that into account. And then there is the perhaps the issue where the contractor is seeking to argue that his delay hasn't caused any overall delay, particularly in circumstances where there is this intervening delay. And in those circumstances, I think tribunal will very easily be able to distinguish between the two and not attribute all of the delay to what might otherwise be called the overriding delay in fact, which occurs later. There might be a view also as to whether a delay that a contractor has caused leads you into a period of time when this difficulty is encountered. And that encountering of that additional difficulty is out with the original contract period. In other words, you've got the original contract period, the delay is going to take you beyond that original contract completion date, and now you encounter this new problem, which wasn't foreseeable. Again, I think tribunal would say, well, if it wasn't foreseeable, we will attribute the further delay to that additional cause. But an argument along those lines might well be deployed, i.e. the contract period has in some way an influence on whether or not you get the consequent delay relief. And
I'm just going to touch on a question in the chat box. How do you quantify, and you spoke at length previously about non-critical delays, and you spoke about the wizardry of software as well. How do you, in your view, quantify delays that are not on the critical path?
Well, you'd have an as-built program which told you when things happened and who caused the problem to that. You'll have an argument, of course, about the float that's associated with that activity. And, you know, those arguments can go either way with different tribunals. Frankly, I think the contractors have the upper hand on that, and that float in a program should belong to the contractor simply because they've priced for it and arranged the work accordingly. But that's not always persuasive to all tribunals. So my answer would be, look at what happened, record it, and then identify those problems that led to that particular activity being delayed, when and at what cost.
I think I will take that as your closing comment, Franco, and the advice there that you've given about how to record the as-built situation, I think is important. Derek, closing comment from you, and it would be remiss of me if I wouldn't ask it around disruption. Given where we're at, and what would be your kind of number one tip to contractors now moving forward in terms of thinking about the disruption claims they're going to potentially be preparing over the next few weeks and months? On the spot question as well, by the way. So
yeah. I guess the thing that they need to have a very clear eye on is how do you record the resources that you have deployed on the project and what the outputs are that you're generating from them. So you want to be in a position where you can actually identify, as I say, early where there is loss of productivity, and then trace the causation of that. So if you don't have visibility of that, you're going to end up essentially putting together something that is less than compelling. So being in a position to identify and then investigate is actually very important. And for discrete things where you have a warning that you're going to have to remove people from the site, etc., that should be very straightforward. It's the less obvious effects of the disruption that then tend to create the difficulty and the evidential material that needs to go with that. So I would strongly encourage people to have a structure to do that, whether that is going through and actually having interviews with people that are actually working on the site to understand what are the hindrances that they are facing. That's what used to happen 25 years ago. There is technology, as you say, that you can deploy, but if you don't already have it in place, you're probably too late to implement that. Sure. The alternative I would suggest is that you have some form of value analysis at different levels for discrete types of work, so that you can actually monitor what is happening in terms of productivity. And that's key to allow you to then do that investigation and bring that material together.
Thanks, Derek. I think record keeping, that the rigor around record keeping and thinking strategy around these claims is absolutely critical. We're on the hour, which means sadly we are out of time. It's certainly a conversation that I think we will hear more of, sadly, over the next few weeks. We certainly hope that things come to peaceful resolution very quickly. Leaves me to say thank you to Franco and Derek. Thank you to Jason, and thank you to the team at Middle East Consultant. And thank you to each and every one of you for joining today's podcast. We wish you a pleasant Eid Mubarak from all of us, and stay safe. Thank you so much.
Thank you.